Morning, Mr. Wolf, Mr. Wilkins.
Morning, Your Honors. May it please the court, Scott Wolf, I am the petitioner here, and I do wish to reserve 5 minutes. If it may please the court, I'd like to start with just reviewing, excuse me, the order that was entered compelling me to provide the information. Specifically, the order stated that this court is within the 2nd District and must follow the Stahl ruling. That's the Stahl passcode case from 2016. And so the entire order is basically relying on that case. The court admits that 3 things need to be established in order to plead the 5th Amendment privilege. 1, compulsion. 2, a testimonial communication or act. And 3, incrimination. The court then went on to say that Wolf has no reasonable basis for asserting the privilege against self-incrimination here and did not seek a protective order in good faith. Doesn't really explain why, but that's what it says. And then says that the documents to be produced are not Wolf's protected testimony, but documents in his possession or control that did not require the extensive use of his mind to create. Finally, the order goes on to say that Scott Wolf must produce the following: checking account locations, account numbers, savings account locations, and account numbers, the identity of any individual or business entity that has loaned him money, what the loan balance is and the monthly payment amount for each loan, and the last 3 statements for each bank, savings, credit union, or other financial account. Additionally, the court ordered that I must, quote, describe all other accounts or investments that I may have, including stocks, mutual funds, savings bonds, or annuities in writing, and produce MMQB Inc. stock certificates. So what we have here, Your Honors, is 2 separate things going on. As you know, the respondent, trustee of my father's bankruptcy estate, and they obtained a judgment in 2018 against me, which is still pending on appeal in the district court, in Northern District of Illinois, in the amount of $2.1 million. And they properly registered that judgment in Sarasota County. And then I was ordered to complete the fact information sheet. That's form 1.977. I completed that form completely, except I withheld some information claiming a privilege against self-incrimination. And the information that I withheld that we're discussing today is that financial information. And there are 2 components to that financial information. First, there's the actual information that I was ordered to describe in written form. That would be bank accounts, stocks, bonds, investments that I may have, mutual funds, savings bonds. I was ordered to describe all of that information in writing. And I was ordered to describe or...
Tell me how a bank statement is incriminatory.
Well, that was the first thing, was the actual information. The second thing that I was ordered to do is produce.
Now tell me how a bank statement is
Right.
incriminatory.
I was ordered to produce any of those bank statements. So the act of producing the bank statement is incriminating, and I'm going to refer to the Stahl case here.
Is what's in the bank account incriminating?
No, that's not why it would be incriminating. The Stahl, Your Honor, so that's not what it would be. The Stahl case here, the act of production doctrine is what the Stahl case mentions. The 5th Amendment privilege against self-incrimination has been held to apply not only to verbal and written communications, but also the production of documents, usually in response to a subpoena or summons, because the act of production itself could communicate incriminatory statements. This is quoting from the Stahl case.
So you would be communicating by divulging it. What?
Invoking the privilege still requires the accused to establish compulsion, a testimonial communication, and incrimination. So we obviously have compulsion because I've been ordered to produce them. I've argued that there's incrimination in producing them, and I've gone into detail. We can touch on that in a minute. And that leaves only the testimonial element, if it is testimonial. And this court said that the testimonial elements of production include 1, the existence of the documents, 2, the accused's possession or control of the documents, and 3, the authenticity of the documents.
When those cases that said production itself was testimonial, what was the crime that the individual would have been essentially testifying to have been committed?
In the Stahl case, it was providing a passcode to a locked phone. And
Yeah, but in the Stahl case, that wasn't deemed to be.
right, the court ruled that that was not incriminating. Here, in this case, as I've argued, and I'll touch on that now, the trustee filed 7 adversary proceedings against me. And in each of the adversary proceedings, he accuses me of having assets belonging to the bankruptcy estate, assets that are part of the bankruptcy estate. If I have assets that are property of the bankruptcy estate, whether they're in bank accounts, stocks, bonds, or whatever, and I did not turn those assets over to the bankruptcy estate, the bankruptcy was filed in 2014, but my father's discharge was not denied until 2018.
So let me ask you this. So if I recall Stahl correctly, you can correct me if I'm wrong. I think it analogized to say the safe, the combination to a safe. Perhaps there's other cases. So if someone's been accused of stealing something, and the government thinks that you might have it hidden away in a safe, and the government asks you for, they get a warrant and they have probable cause, and the government asks you for the combination of the safe.
Right.
Under Stahl, that would not be something for which you'd be able to invoke your Fifth Amendment right.
That's because in Stahl, the court determined that it was a foregone conclusion that that information existed, that the existence of the passcode existed. The state knew that this defendant, Stahl, had the passcode, and that it would not make
Yeah,
extensive.
but it's a foregone conclusion that you have bank accounts, right?
No, that's contested. There's been no evidence. The court never ruled that I have any bank accounts. There's been no information provided that I have anything. And the Stahl court described that. Let me just get that for you.
And if I may, since you don't have anything, just responsibly, I have none. And why would that be incriminating? Simply say, I have no accounts, because the form that they've used is a Florida Supreme Court form that is standard provided in all these type of cases. And as you can imagine, Ms. Rolfe, you're not the first one who's been the recipient of that. Usually people have vigilance against that. This is a standard form that's set. The question becomes is that you are indicating that somehow this is incriminatory. And so incriminatory for what? And I guess it follows what Judge Rose and Judge Atkins are asking. What is it about it being incriminatory?
Well, any bank accounts that I may or may not have are not known. There's no, you need to produce your bank statements from XYZ Bank. This information is not known to the state. It's not known to the trustee. So by producing the document, that would be a testimonial act.
So, but let me follow that. So, by divulging that you have bank accounts, that it's not a criminal offense to have a bank account, right?
You can have a bank account.
Right. That's not a crime. The crime would be having something in that bank account that was ill-gotten, that you were not supposed to have, right?
Well, just with besides bank accounts, you have stocks, bonds,
It's
having
not
those
even-
assets.
It's not even
maybe-
necessarily a crime. What we're really talking about is looking at assets that may have been fraudulently transferred in proceeding in execution of the judgment.
But if those assets that I have, right, if those assets should have been or are property of the bankruptcy estate, because that's what the trustee has claimed that they are, then I have those illegally.
So, okay, let's assume for the sake of discussion that it's criminal
Right.
to have them,
Correct.
right? So, having a bank account is not a crime. Everybody in this room probably has one, right?
Right.
But the crime, for the sake of discussion, is having something in the bank account that you're not allowed to have,
The
right?
example of.
So,
bank account.
so, right, so that's just like a safe. It's not a crime to own a safe. But it is a crime to have stolen goods in the safe. So that's why just telling the cops, I have a safe, is not a violation of one's right to against self-incrimination. And just like while the contents, having something one shouldn't have on a phone, the contents themselves might be a crime. Telling the cops that I own a phone. Owning a phone is not a crime. Having a phone that's password protected is not a crime. So that's why this might very well be analogous to Stahl and to the safe, because owning a bank account is not a crime. Having a bank account number is not a crime. The crime might be what you put in the bank account. So like Stahl and like the safe, it seems the trial court might have followed the law that he or she had to follow, which is to say that just by telling someone, I have a bank account, I have a locked shed, here's the combination to the lock, is not requiring that person to violate their Fifth Amendment rights or to give up their Fifth Amendment rights.
Well, I disagree respectively in a number of different ways. First, in this instance, in the Stahl instance, we knew that there was a safe, for instance, and that was the phone, the locked phone. Here, that information is not available. We don't know.
But is it a crime to have a bank account?
It could very well be a crime to have a bank account. For instance, if you have financial bank accounts offshore and you didn't report those to the IRS.
Is that the crime that you feel like you would be incriminating yourself as having committed an offshore bank
That was
account?
one of the allegations that was leveled against.
So the crime itself is just having an offshore bank account.
Well, in your example, that would be, there are instances where having a bank account would be a crime. Yes. However, the case law goes much further in terms of not just the actual document itself, but if the information that you're revealing, in this case, I'd be revealing the existence of bank accounts. If that forms a link in the chain of evidence that can prove further prosecution, then it's protected under the Fifth.
Wouldn't the passcode to a phone be a link in the chain of evidence? In other words, the same type of link, meaning how, sir, are we allowed to, how would we ever be able to know what you have on your phone with the password, right?
Well,
How are the powers that be ever going to know what's in your bank account if you don't give them access to it? Just like the access to the safe.
well, I would say in terms of the passcode case, obviously the Supreme Court is gonna, figure that out one way or another here shortly. But the difference is that the passcode was a known entity. You were able to apply the foregone conclusion test and say that we can deny the active production doctrine, we can deny the privilege against self-incrimination, because the state already knows that you have the passcode. It's in your mind. And this court ruled that all you need to do is provide that passcode, and that passcode itself did not have any incriminatory value. It was just a passcode. Having that passcode could not incriminate you in a crime. However, having a bank account, having stocks, having bonds, or any other assets that could be property of the bankruptcy estate would incriminate you in a crime. So the mere fact that I would relay that information or produce documents which would confirm the existence of the documents, which would confirm the existence of the account, and confirm that the account is in possession or control, I'm in possession or control of the documents, and the authenticity of the documents, that could lead to criminal charges against me.
But
That could lead to
you
a
did
criminal
provide-
investigation.
My understanding is you did provide similar information many years ago.
I provided the information in 2015, and I can get this right here for you. Here it is. In order for the foregone conclusion doctrine to apply, the state must show with reasonable particularity that at the time it sought the act of production, so not in 2015, but the time it sought it, it already knew the evidence sought existed. The evidence was in the possession of the accused, and the evidence was authentic. In this case, the information sought is unknown. No information about bank accounts, stocks, bonds, any other financial assets. So it's not a foregone conclusion that the state, or in this case, the trustee, has shown that at the time the information was sought here in the post-judgment, discovery proceedings, that it knows that this evidence exists. It has no idea what evidence exists. It could do an investigation on its own. The trustee could undertake, send subpoenas out to banks. I don't know. It can, obviously the Fifth Amendment doesn't prevent wide-ranging investigation.
Have you ever heard the short story "The Telltale Heart" by Edgar Allan Poe? Well, anyway, I won't use that. But let's say the police officers investigating a murder wonder whether the perpetrator has hidden a body underneath his or her house. Would it be a Fifth Amendment violation to say, if they're talking to the potential suspect, do you have crawl space under your house? And if he said, could he say, no, I have the right of, that would incriminate me to just say that there's crawl space under my house.
I believe in a certain circumstance it could, sure, yes. Because,
Because that would be a place one could hide a dead body.
right, and that, and having, knowing that you know that there's a crawl space, or knowing there's a crawl space, you don't know if the police know there's a crawl space or not. But you're providing, if they go and find the crawl space themselves, more power to them, they can do whatever they want, right? They can investigate whatever they want, but you don't have to help their investigation, that's what the Fifth Amendment protects.
Mr. Wolf, excuse me for interrupting you. You're into your rebuttal time. Use it as your time.
I'll save it. Thank you.
Thank you. Mr. Robbins.
If it may please the court, Mark Robbins, on behalf of the Chapter 7 trustee of the Michael Wolf bankruptcy case.
And Ms. Wolf, the question that I've asked Mr. Wolf before, these are standard forms that have been approved by the Florida Supreme Court. Nothing in there to require people to divulge any incriminatory statement. Was there anything other, because I see here in the record, these appear fairly standard to me. Have they been changed in any way from the forms?
Not that I'm aware of. The Form 1977 is specifically for the help judgment creditors collect on their judgment debts.
And just to let everyone know, before a Florida Supreme Court approves a form, you could imagine the steps that are involved. Everybody, all the stakeholders participate. Everybody has a comment on it. And there's a period of time that takes place prior it to become, this is going to be official. And so there's nothing in this form that took it out of the ordinary. Nothing has been amended or changed in any way.
Yes, Your Honor. I believe this particular form is several decades old and has been around for quite some time.
Correct.
Without any substantial change or any other modifications or amendments.
But even with the form, Mr. Wolf makes an argument that the trustee has in the past, I don't want to say threatened, but suggested that there may be criminal charges he might pursue as opposed to just merely trying to recover assets.
Well, the Chapter 7 trustee has no authority to conduct any prosecution.
He can refer.
He can refer, yes, Your Honor, he can refer what he thinks might be considered a criminal prosecution to the Department of Justice in that case, but that is not the standard here. The standard is whether or not there's a rational basis to conclude that the assertion of the Fifth Amendment has a basis in fact.
Isn't it a reasonable possibility?
Is it on a judgment, on a collection of a judgment debt?
He has to show a reasonable possibility.
Well, first of all, the alleged fraudulent transfers that he's referring to occurred prior to the bankruptcy cases in 2014. So there's an issue there. As far as to whether or not it's possible, sure. The facts of the case, I think, if he's made the assertions that there is in fact some sort of fraudulent transfer, or there is potentially some sort of criminal activity that could have or may have occurred. And he points to the potentially tax returns or some sort of fraudulent transfer within that might be disclosed in bank statements. This case is now 8 years from the original petition date, which was in July of 2014. And the further we get away from it, the less that I see the connection between bank statements in 2022 with a criminal prosecution for something that may have occurred in 2014. And please don't forget that, fraudulent transfers have both a criminal flavor and also a civil flavor. So the bankruptcy trustee has avoidance powers under the bankruptcy code to seek avoidance of fraudulent transfers. And I think that's what the complaint was all about. And I want to point out that this is a civil matter. This is not a criminal prosecution.
But it's not completely out of the ordinary to invoke one's Fifth Amendment right in a civil manner.
Absolutely, that's correct. The Fifth Amendment certainly can be applied in a civil matter or civil concern. Again, though, when it refers to incriminating evidence or the.
Well, you're just saying that goes to the element, for lack of a better term, of that the person asserting the privilege needs to establish, which is that the criminality, the
Yes,
incriminating nature,
or at least that there's a rational basis.
rational basis that divulging it would incriminate oneself.
Correct. And that does not take away from the prong on the testimonial communication requirement. The testimonial communication requirement establishes that you have to have the contents of one's mind was instrumental in creating these particular records. For example, you know, the bank statements that we're talking about are not created by Mr. Wolf. They are created by a bank. They're bank records. There's bank records that involve what is ordinary conduct. For lack of a better term, if one was to look at the rules of evidence, especially with respect to hearsay, for example, there's an exception to business records because those are not testimonial within the nature of the rules of evidence. Like that here, it is not testimonial because it is not created from the contents of his mind. It is bank statements. These are ordinary transactions. He goes to a gas station and uses his debit card or his credit card, and it shows up in a bank statement that he has paid or charged that. The other,
But then it's the fact that there was a debit transaction that might be used to show where he was at a particular time.
it's theoretical. The more attenuated we get away from the incident, the less connection it has to a criminal behavior or a criminal act. And again, when referring to the Fifth Amendment, we're talking about what it only protects the defendant's testimony. It does not protect, you know, other types of evidence. And I think Fisher versus United States made that quite clear. Is that just simply because it exists does not necessarily mean that it is criminal, even if the document itself could lead to incriminating evidence. In Fisher, this wasn't about work papers that were held by an accountant. And the documents themselves, the Supreme Court found that were not testimonial because they were not something that was expected to be, that was created by the contents of the defendant's mind. And in that regard, it's a little bit more analogous. In this case, it's more analogous to Fisher than it is to Stahl. Stahl, as we mentioned, the safe analogy, as we mentioned earlier. In this case, this is more likely that somebody else has the documents. You know, in the deposition in 2015, Mr. Wolf, the petitioner, testified that he had bank accounts at Wells Fargo. Post judgment, we sought to garnish the Wells Fargo account. Wells Fargo came back and said there wasn't anything there. So the point being that when it refers to testimonial evidence, if somebody else has that information. Are there any questions?
Thank you, Mr. Roberts. Mr. Wolf.
Thank you. Just to address some of that real quickly, I only know I have 5 minutes. When he here says that someone has that information, I would conclude that that information only exists in my mind. Bank account, stocks, bonds, all that information is in my mind. And
That's a very broad rule. I mean, you would bring, you know, supplementary proceedings to a complete halt.
I disagree because this is a very unique case because most supplementary proceedings are purely civil matters. They don't have extra criminal statutes, 18 U.S.C. 152, bankruptcy crime. That's what's associated here. And on that point, we have 18 U.S.C. 3284, which contains a special statute of limitations, which applies to concealment of assets. The concealment of assets of a debtor in a case under Title 11 shall be deemed to be a continuing offense until the debtor shall have been finally discharged or discharge denied, and the period of limitation shall not begin to run until such final discharge or denial of discharge. Now, we do have a denial of discharge about 4 years ago, a little less than 4 years ago. This is a 5-year statute of limitations, so obviously still some criminal liability there, but the underlying bankruptcy case is still open. So I don't even know if you would consider that a final discharge, is a final order in the bankruptcy. Hasn't been issued yet, and the case is still open. So there is a special statute of limitations. It doesn't matter if this goes on for another 20 years. This 18 USC 3284 tolls the time until there's a final adjudication of the case. I wanted to bring up contents of one's mind used to locate the statements. I touched on that this information is in my mind, the location, whatever may exist, whatever stocks, bonds and all that. That information is in my mind. I've never admitted that anybody else would have that information, or I've never admitted that I have an accountant. Obviously, if I had an accountant, I could have subpoenaed the accountant and gotten any records they want, because there is no privilege. So none of that is on the record or exists. And the same thing, collection of a judgment debt. This is a unique case in the sense that there are federal criminal statutes attached to it. And that obviously changes things, and I'm sure 99% of the collection cases down there in Florida aren't a Chapter 7 trustee initiating collection proceedings. So this is not some kind of case that would just render supplementary proceedings irrelevant. And to that point, Your Honors, it's sort of like the trustee, obviously a Chapter 7 trustee, been doing it for 20 years. He's aware of all these laws. He's aware of the criminal statutes. He accused me of many of them. And he's aware of Fifth Amendment privilege. I actually invoked the Fifth Amendment privilege in 2018 within the bankruptcy case, within an adversary proceeding. And it was deemed to have been waived because I didn't bring it up when I first provided discovery. However, the bankruptcy trustee is aware of it. So that argument is a little bit like American Express coming in and saying it's unfair that they got a judgment against somebody for $50,000, but they have a $2 million homestead and they can't collect from it. It's not fair that there's unlimited homestead. The homestead is protected from judgment in Florida. But they already knew that going into it, and they still loaned money to people in Florida. The trustee initiated these adversary proceedings knowing full well that he was accusing me of criminal crimes, that he was accusing me of having assets of the bankruptcy estate that I did not turn over to him. So it should not come as some sort of surprise that I may want to invoke my privilege against self-incrimination. Something reasonable that many people do all the time because they just don't need, and the Constitution, both the Florida Constitution and the US Constitution protects them. And that other last point that I wanted to make here, this is from the 3rd District, Florida. The standard for deciding whether the Fifth Amendment has been properly invoked in a civil proceeding is whether, quote, the civil litigant has reasonable grounds to believe that direct answers to deposition or interrogatory questions would furnish a link in the chain of evidence needed to prove a crime against them. And I'm contending that the act of producing these documents is testimonial in nature because it proves their existence. And by testifying that they exist, I have furnished the link in the chain of evidence. Because right now, there is no knowledge that they exist, as was admitted that they don't have any information whatsoever, any testimony that I gave.
But you're not being asked to divulge whether any of the assets in these financial vehicles or accounts are assets that, you know, you fraudulently transferred or that you absconded with. You're just being asked, essentially, you're just being asked whether you have accounts.
Well, accounts, stocks, bonds, things like that. I could have stocks that formerly belonged to the debtor, maybe should still belong to the debtor and therefore be in the debtor's bankruptcy estate. So it's not just accounts and bank statements, you're talking about actual assets that I'm being asked to provide in writing. So having, just the fact having those would be incriminating and certainly would form a link in the chain of evidence necessary to prove a crime.
Mr. Wolf, you're gonna have to wrap it up, please.
Anyway, I think I covered all that. And as regards to Form 1.977, even though it may be a standard form, obviously if it asks for information that is privileged against self-incrimination, it's unconstitutional. And regardless of how long it's been in existence or how many people have used it, certainly if it asks for information that's privileged, in this case privileged against self-incrimination, Constitution of Florida and United States obviously trump the information on it.
Thank you, Mr. Wolf.
Thank you.
Thank you both.
Thank you.
Have our lawyers showing up for the second case, Ramsey versus Yes, Hospital, okay, we're gonna go back and do that case if everyone's here.